So the issue of concealed carry bans and the outright defiance of the Supreme Court's Bruen decision is now once again back in front of the Supreme Court. So let's break down what is happening. Now, really quick before we jump into this video, I want to ask you guys for a favor. Looking at some of my analytics, about 58 to 60% of all viewers are actually not subscribed to the channel. So if you want to support the channel for free, please consider subscribing. By no means do you have to. And then also just drop a positive comment down below that tells the algorithm that you appreciate this type of 2A content and other type of 2A content, and then it pushes those videos to more people. As I mentioned in the intro, in this video, we're going to be discussing how the issue of concealed carry bans in New York is once again back in front of the Supreme Court. You may recall that the Supreme Court recently granted, vacated, and remanded a case called Antonyuk back down to the Second Circuit Court of Appeals for a new decision in light of what they said in an 8-1 decision in a case called Rahimi. The Antonyuk case challenged the state's new hyper-restrictive concealed carry law, which is known as the CCIA, the Concealed Carry Improvement Act, and that passed just 8 days after the Supreme Court issued their Bruen decision. Now, Bruen, of course, struck down the prior New York carry ban, but the state of New York decided that they wanted to defy the Supreme Court and passed a new law. On review of that new law, the Second Circuit issued a new decision on this whole concealed carry ban, and essentially they reissued the same decision, finding that Rahimi did not change the outcome of their analysis at all. In response to that horrible decision, the plaintiffs have once again sought Supreme Court review, and they're hoping that finally the Supreme Court will once again get involved and strike down the second iteration of the New York carry ban. And now this case will once again go in front of the Supreme Court. It is now set for conference in just 2 weeks. Now, the issue of concealed carry bans specifically in New York should have really ended a long time ago after Bruen. The new Concealed Carry Improvement Act law was challenged in multiple cases after Bruen, and multiple preliminary injunctions were granted, halting various aspects of the CCIA. However, the state of New York appealed those decisions to the Second Circuit, who then granted some blanket stays, allowing that law to move forward. At that time, that led the Antonyuk case and some others to seek Supreme Court emergency intervention, but at that time, the Supreme Court did not want to get involved. Recently, the Second Circuit ruled in 5 of the CCI preliminary injunction cases, and the Second Circuit ultimately vacated a lot of the lower court decisions, finding that the good moral character determination does not violate the Second Amendment. In their decision, the Second Circuit distinguished this case from Bruen. They claimed that Bruen was an exceptional case, and here this Antonyuk case dealing with the CCIA is different and not exceptional. In response to that Second Circuit ruling, GOA then filed a second petition for emergency Supreme Court intervention. Although this case was still in an interlocutory posture, the Supreme Court did actually GVR, which means they granted, vacated, and remanded the case back down to the Second Circuit for a new decision in light of the 8-1 decision in Rahimi. Now, after the Supreme Court GVR'd Antonyuk back down to the Second Circuit, you would think that the Second Circuit would kind of get the message and at least attempt to faithfully review and apply the Bruen and Rahimi standard. But of course, they didn't do that. Instead, they wrote a 246-page opinion essentially saying that Rahimi does not change the outcome of this case at all, that the Bruen and Rahimi analysis don't really apply, and that this issue here is not exceptional like what happened in Bruen. But because of that egregious decision, this case is now heading back in front of the Supreme Court and is now set for conference in just 2 weeks. In the petition for Supreme Court review, the plaintiffs here argue that repeatedly, the panel asserted that it was not bound to apply Bruen's methodology, surmising that Bruen was a case of exceptional nature, and courts maintain flexibility when examining less exceptional regulations. The panel repeated this claim no fewer than 4 times to justify circumvention of Bruen's framework. The panel cited a recent law review article that labels Bruen unsatisfying, claims that Bruen places outsized importance on historical silence, and suggests judicial responses to that decision in order to read Bruen narrowly and engage in the time-honored practice of narrowing Supreme Court precedent from down below. If Bruen left any questions unanswered, Rahimi laid those to rest. Contrary to the panel's insistence that Bruen was an exceptional case that warranted uniquely heightened historical stringency, Rahimi confirmed that the Bruen analysis simply was the appropriate analysis. Thus, Bruen and Rahimi established the norm and do not permit a more nuanced approach whenever a court declares a challenge regulation to be less exceptional. But the panel read Rahimi differently, casting it aside as having little direct bearing, despite being the reason behind the court's remand. So this petition by the plaintiffs, including GOA and others, not only outlines the clear Second Amendment precedent that should find that the New York CCIA law is in fact unconstitutional, but it also shows what lengths the Second Circuit went through to defy the Bruen and Rahimi decisions. New York has filed their opposition, arguing that the Supreme Court should not grant review to this case at all. The main thrust of those arguments presented by the state of New York are that this case is too early for Supreme Court review, that they shouldn't step in at this early stage, that the state should be allowed to rely on later history to justify this type of restriction, and that the plaintiffs don't have standing to actually challenge the good moral character determinations and requirements that are included in the CCIA. In arguing that this case is too early for Supreme Court review, they state that, as an initial matter, this court's ordinary practice of denying interlocutory review is especially advisable here, where the Court of Appeals merely found that the plaintiffs did not establish a likelihood of success on the merits at the preliminary injunction stage, either for a lack of standing or for a lack of meritorious legal claim. The preliminary injunction record in this case was developed in a matter of just weeks, and no fact or expert discovery has yet taken place. Further litigation may obviate any need for this court's review, and at a minimum, such review should be aided by a complete record and merits determination. So the state of New York's argument is that the Supreme Court should just not get involved right now. Instead, they should let the lower court actually issue a merits decision. They then argue that 19th century history and potentially later history should be allowed to justify this type of restriction. They state that this court has never held and should not now consider holding that 19th century history is categorically irrelevant in evaluating Second Amendment challenges. To the contrary, this court and numerous courts of appeals have routinely considered such history in evaluating Second Amendment challenges to firearms laws. Now, the goal of New York here is to shift the historical analysis further away from the founding era, shifted away from 1791 into later history and later state, actions and other, national actions at a later period, so that they have some sort of justification for what they're doing here with these carry bans. Finally, the state of New York walks out kind of the old standing issue in arguments. They argue that none of the plaintiffs here have actually applied for the new permit and then been denied based on the good moral character determination and that type of requirement that's included in the CCIA. They argue without the denial based on good moral character, then their challenge fails and is now invalid. So New York is pulling out all the old tricks to try to avoid Supreme Court review. What is interesting about this case is, even though it's still in an interlocutory posture, it deals with a state law passed in direct defiance to what the Supreme Court said in Bruen. It also involves a court kind of failing to apply Bruen and the Rahimi analysis, and all of that happened even after the Supreme Court GVR'd this case prior. But now this case is heading back to the Supreme Court for consideration. The case has been filed for Supreme Court cert, and it has been set for conference on March 28th. So in just a couple weeks, the Supreme Court will get together and determine whether or not they want to reconsider this issue and ultimately, once again, try to strike down a New York carry ban. Also, the issue of a circuit court just outright defying and refusing to apply Rahimi and Bruen will also be up for consideration. So we're going to be watching this closely to see how this develops, to see what the Supreme Court wants to do. Like I said, this not only would impact the state of New York, but other states that have similar laws like California and Hawaii. So we're all going to be watching this. As we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you guys for watching. Don't forget to like, comment, and subscribe. And never forget, the station was built by Armed Scholars, and the station will be maintained by Armed Scholars.